Sometimes a civil sexual assault lawsuit can be a healing step in your journey, but there are considerations that need to be given to various elements that make a case strong. I'm Natalie Gerry from Gerry Law. I help injured people get the compensation that they deserve for their injuries. Today, it's a serious topic, but it is an important one, and this is the considerations in a civil sexual assault lawsuit. I'm often asked in my practice, would it be worth it for me to bring a civil sexual assault lawsuit? And my answer depends on various aspects of your case. And this is really specific to everyone's particular circumstances. It's important that you get tailored legal advice. And I can be contacted in the information below, and I'm happy to give you advice about your particular circumstance. But today I'm going to go over the 3 key elements that have to be present in order to make it worth your while to bring a civil sexual assault lawsuit. Let's get into it. Let's get into those 3 factors that make up a strong civil sexual assault lawsuit. Those 3 factors are liability, damages, and the ability to enforce a judgment. Starting out with liability, let's talk about what that even means. The term liability means that a legal wrong has been committed. With sexual assault, there are black and white situations, and then there are areas of gray. This is when it comes to liability. Obviously, any sexual contact with a minor under the age of 18 is legally wrong, and liability would be established if we can establish that sexual contact happened with a minor. Additionally, any sexual contact with an adult who is not truly consenting is sexual assault. Still, even the concept of consent itself can be a complicated area. In Canada, the law is that consent cannot be considered valid if it's obtained through threats, intimidation, or a breach of fiduciary duty, such as a doctor-patient relationship. In Canada, the law states that consent must be clear, informed, voluntary, sober, act and person specific, ongoing, mutual, active, and it must come directly from the individuals participating in the sexual contact. Beyond consent, it's important to consider the perpetrator. For example, in some cases, the perpetrator admits that the abuse occurred. However, if the perpetrator does not admit to the assault, then the burden is on the plaintiff to prove that the assault happened. In such cases, the best evidence would be a prior criminal conviction against the perpetrator for assaulting the plaintiff. So this would be in the criminal court. If there was a successful prosecution of the perpetrator, that would be the best evidence. After all, if the perpetrator has been convicted in the criminal trial or has pled guilty, the plaintiff can use that conviction as proof in the civil case. And the burden of proof is higher in the criminal context because it is beyond a reasonable doubt, whereas in the civil context, it is just a balance of probabilities, and I shouldn't say just, but it's a lower standard of 50% plus 1, which is advantageous to the plaintiff in the civil claim. In the case where the perpetrator has been acquitted or has not been convicted yet, or the survivor has chosen not to pursue a criminal charge against the perpetrator, this doesn't mean that liability cannot be established. Even if there was an acquittal in the criminal trial, there can still be liability in the civil suit because it is a separate court. In terms of proving liability in the civil context, what the lawyer will do then is look for corroborating evidence to support the testimony of the survivor. That being said, there doesn't always have to be corroborating evidence because frequently this is a situation where there are no witnesses. It could be that it's just the perpetrator's word against the survivor's word. And there are cases where the defendant has been found liable to the plaintiff just based on the word of the plaintiff versus the word of the defendant. Another aspect of liability is related to the enforcement of a judgment, and this is in terms of the concept of liability and how it can be extended to organizations or other overarching organizations that may be responsible for the defendant's conduct at the time when the sexual assault occurred. Sometimes the organization can be found to have played a role or facilitated the abuse. The perpetrator may be employed or affiliated with an organization at the time of the abuse, and therefore the organization would be vicariously or directly liable. For example, in the case of priests or the clergy, the church may be liable for the abuse. Similarly, with teachers, the school board may be liable. In examples of abuse by foster parents, the Children's Aid Society could be responsible. Just depends on the situation. There could be multiple parties that are liable. So it is important to get specific legal advice on your situation. When seeking to find an institution liable, in addition to the person who perpetrated the abuse or instead, the plaintiff and their counsel have two options. So there is direct liability and then there is vicarious liability. Vicarious liability is also known as automatic liability, and this has to do with the organization creating the stage sort of for the abuse to happen. This could be because they allowed access to, say, children in the context of a school and allowed a private room for teaching, which could have facilitated abuse happening. In this case, there is a strong argument that there could be vicarious liability. In other cases, the institution is liable if it was negligent. This means that its processes or representatives fell below the standard of a reasonable institution and acted unreasonably. Common examples include failing to check the perpetrator's references or arrest record, or failing to properly respond to an investigation. In terms of if there were reports of previous abuse and they failed to look into it, then that would be a strong indication that they were negligent and liability could be established against them. In civil sexual assault cases in Ontario, damages. Next, we're going to talk about damages. This is the second part of a civil sexual assault lawsuit that is really important and that the plaintiff must prove. In civil sexual assault cases in Ontario, damages serve a crucial role in recognizing and compensating the harm done by the perpetrator. This isn't the criminal system where there could be jail time. This is the civil system where the wrong is compensated to the party that has been wronged in terms of financial compensation. So the person who has been wronged would be entitled to financial compensation, but they have to prove damages. So this means that the survivor or victim has to prove how the assault or abuse has affected their life in a negative way, and the court will then try to craft a remedy in terms of damages to compensate the plaintiff for what happened. In our legal system, there are various types of damages, and I do have another video about damages specifically that will be linked below that gets into all the types of damages, but right now I'm just going to talk about the two overarching types. There is the non-pecuniary damages, and then there is the pecuniary. What this means is the first is non-pecuniary, and that is something that is less able to be quantified. It's also known as general damages. These are awarded for non-monetary losses suffered by the survivor or assault victim, and this includes things like pain and suffering. General damages are awarded for things like pain and suffering or emotional distress, things that have been caused by the assault or abuse, but they cannot be measured with money necessarily. It's not a therapy session where the cost is $200 per session. It's something that the courts have to assess how much the survivor's life has been impacted by the instances of assault or abuse and put a figure on that. And it's really based on previous cases and comparing the relative amounts of damages in those cases compared to what happened in the survivor's case at hand. In recent years, the Court of Appeal has emphasized that the amount of general damages should not be modest, even in the case of a single incident without a breach of fiduciary duty. For instance, in a 2019 case involving a doctor who was assaulted by a colleague, and she was assaulted. It was one instance of assault, but even so, the court took it quite seriously in terms of awarding damages. She was awarded $175,000 in 2019 for general damages. These amounts would be indexed for inflation to show the current day value, but this amount was awarded in terms of colleagues. It wasn't a situation where there was a minor involved, which would be an aggravating or worsening factor, or where there was a fiduciary duty, such as a priest and the priest's subject. This decision reflects a growing awareness in the court system of the severity of sexual assault and how badly it can affect people's lives. This type of award does give recognition to the fact that it can have a long-lasting and horrible effect on a person's life. Now, let's move on to the enforcement of a judgment. In Ontario, the enforcement of a judgment in civil sexual assault cases largely hinges on the perpetrator's ability to pay that judgment. For instance, if the perpetrator lacks the financial means to pay a judgment, then there are other options, normally in terms of assessing if there is property. A search can be done to determine if the perpetrator owns any property and if there would be sufficient equity in that property to pay a judgment. You really need to speak with the lawyer about this because it has to be looked into pretty carefully, and the lawyer will know how to do that. There are instances also where the perpetrator's employer or another organization can be on the hook for the perpetrator's behavior, and this can be helpful in terms of getting the judgment paid. Because even if the perpetrator themselves has no money, has no house, has no assets that could be garnished or taken and sold, the organization most likely does have either insurance or has assets that can satisfy a judgment. As I was previously mentioning, in cases that involve a priest or teachers or government employees, the institutions may be held responsible in cases where there is vicarious liability or where there was negligence on their part. If there is no institutional affiliation, there are other ways to look into having the judgment paid, and this involves doing property searches and writ searches, and at times a portion of the perpetrator's income can be garnished in order to pay the judgment. In wrapping up, prosecuting sexual assault is critically important. Indeed, many survivors of sexual assault are seeking closure and a way to heal and move forward from what happened years after the abuse. Survivors need a safe place to discuss their options, to be heard, and to have their legal options presented to them in a confidential setting. It takes a lawyer who has dealt with this type of issue before and who has experience in discussing these matters, and it's a very important aspect of the Canadian legal system. I am available for a consultation if anyone needs to talk. Please contact me at the information below, and please feel free to check out my other videos on these types of issues and other legal issues. I'm Natalie Gerry from Gerry Law.